Have you ever stopped to consider how much of what you know is based on hearsay? What if one day you found yourself in a situation where hearsay was all you had? Hearsay, a term composed of two words, hear and say, refers to second-hand information about an offense, often relayed by someone who neither witnessed the event nor was present when it occurred. This type of information is typically based on what someone else has told them about the event. Renowned philosopher Jeremy Bentham defines hearsay as supposed oral testimony, transmitted through an oral delivery of evidence from a supposed extrajudicial narrating witness who delivers the information viva voce in a judicial setting. In simpler terms, hearsay is a statement provided by someone who has not witnessed the original event but has heard about its circumstances from a third person. Compared to direct testimony by witnesses, hearsay is typically considered an inferior form of evidence. This is because it involves information that the person providing it did not directly witness or experience. However, there are instances when hearsay becomes relevant. Firstly, hearsay can be ratified by an admission or confession. Secondly, it can be mentioned in any public document or presumed by the court. Lastly, it can fall under the ambit of certain legal provisions, like Section 6 of the Indian Evidence Act. Despite these exceptions, hearsay is generally excluded as a form of evidence. The main reason for this is that hearsay is considered weak evidence that cannot be tested by cross-examination. Furthermore, evidence under hearsay is not given on oath, which can potentially increase opportunities for fabrication. Its exclusion is a protective measure in legal investigations designed to maintain the integrity of the process. In conclusion, hearsay is second-hand information that is generally considered an inferior form of evidence due to its inability to be tested by cross-examination and the potential for fabrication. However, there are certain instances when hearsay becomes relevant, such as when it is ratified by an admission or confession, mentioned in a public document, or falls under certain legal provisions. Despite these exceptions, hearsay is generally excluded to protect the integrity of legal investigations. The world of hearsay is a complex one, but its understanding is crucial for anyone navigating the legal landscape.